Welcome to the Sacramento Superior Court Child Support Department. Today we will be hearing cases involving issues of parentage, establishing and modifying child support and possibly spousal support, determining back due child support, also known as arrears, and health insurance. We will not hear issues relating to custody other than to establish what the parenting time is. The judicial officer hearing your case today is a commissioner who is sitting as an assigned temporary judge. If you object to this person sitting as an assigned temporary judge, you must announce your objection at the beginning of your case. If you object, the commissioner will still hear the case, but will make findings and recommendations which will be forwarded to the supervising family law judge for entry of the order. If parentage is an issue in your case, parentage may be determined in several ways. Parentage is presumed if a child is conceived and born while the parents were married and living together. Also, if you have taken the child into your home and you have held the child out as your own, you may be found to be the legal parent. If you signed a voluntary declaration of paternity, that declaration has the effect of a judgment of parentage. The testimony of a known parent may also be sufficient evidence to establish parentage. If you deny that you are the parent and parentage is at issue, the court may order genetic testing to determine if you are the parent. Most cases involve determining child support. In calculating child support, the court must determine the incomes of the parents as well as additional information about deductions such as union dues, retirement contributions, health insurance premiums, and information about other children or support orders for either parent. In addition, it is necessary to determine the amount of time that each child spends with each parent. Once this information is established, the court must calculate child support based on a mathematical formula provided by the legislature. Generally, this formula will determine the amount of support, but occasionally the court may, for specified reasons, determine that it is appropriate to deviate up or down from the guideline amount of child support. Child support is generally ordered to be paid through an income withholding order, also known as a wage assignment. If you are self-employed or receive Veterans Affairs benefits, you will have to pay the support on your own. In some cases, on request, the court may stay the withholding order so long as you timely pay the support on your own. If child support has previously been ordered, you may be asking the court to modify or change the amount of support. In order to modify the support, the court will need to find that there has been some change in circumstances to justify a change in the support order. Changes in circumstances could be a change in custody, the visitation schedule, an increase or decrease in income, or a change in a parent's family structure, such as a new child in your home. If circumstances have changed sufficiently, the court will recalculate the child support and change the order according to the guideline formula. If you have fallen behind in your support payments, the court will consider how much you need to pay to catch up. In some cases, you may be entitled to credit if the child lived with you for a time and you provided directly for the support of the child. The Department of Child Support Services will request the court to order one or both of the parents to provide private health insurance for the child or children. When one parent is on Medi-Cal, the order to provide health insurance will direct the other parent to provide this insurance if it is available through employment or at low or no cost, 5% of gross income being the threshold. If it is available through your employment but will still be too expensive, you need to document the cost to DCSS to avoid them sending a letter to your employer directing them to add the child or children to your policy. If you later believe the insurance through your employment is too costly, you should contact the Department of Child Support Services or the court and request that the order be changed. The court will generally order that the parents share equally the expenses for health care that are not covered by insurance. To be eligible for this cost sharing, the parent who incurs the expense must provide documentation of the expense to the other parent, after which that parent is then required to cover their share of the expense. Payment will either be directly to the treatment provider if it has not already been paid, or reimbursed to the paying parent. In cases where there is a large difference in incomes between the parents, these expenses may be apportioned according to each parent's earnings. The court may decide other issues that have been raised by the pleadings. The court has no authority to enter orders on issues not raised by the pleadings unless all parties agree. For instance, there may be an agreement on custody or visitation. The court can accept the agreement, also known as a stipulation, and it will become part of the order. If there is no agreement, a request for order needs to be filed by one of the parents to get a referral to mediation and a court date, and if custody and visitation are being reviewed, it would be appropriate to ask to revisit child support, which, if done in the same request for order, will be heard on the same day after the custody hearing. When your case is called and you are called upon to speak, please direct your comments to the court, not to the other parent, and limit your comments to the issues that are properly before the court. The clerk will be preparing the order after hearing, which will be available online, and a copy will be mailed to you by the Department of Child Support Services.